Why do I have to follow a madhab? Why can I not read a hadith book and act upon the hadith myself? It's sunnah. Can I mix between different madhahib? If you have these questions, then this video might be useful to you. So let's start. Bismillahirrahmanirrahim. As-salatu was-salam ala Nabi Muhammadin sallallahu alayhi wasallam. I'm Sa'iqa, a qualified alima, and my today's topic is the development and formation of the schools of law with a focus on the Hanafi school of law. I'm going to divide my talk into 4 sections because the Hanafi school of law, like many other schools of law, it took 4 centuries for it to develop, for it to form as a school of law we know now. So I'm going to divide this into 4 sections, starting with my first section, which is the 1st century, the beginning of the Hanafi school of law. Now, the Hanafi school of law, its birthplace was Kufa. Kufa was conquered during the Khilaf of Umar radiallahu anhu. He sent Abdullah ibn Mas'ud radiallahu anhu as a qadi to Kufa. Later on, Ali radiallahu anhu, when he became a Khalif, he shifted the Muslim capital from Medina to Kufa. So the fiqh of Kufa is heavily influenced by Abdullah ibn Mas'ud and Ali radiallahu anhuma. So for example, both of them, they are the teachers of a great tabi'i called Alqama. Alqama is the teacher of his nephew Ibrahim al-Nakha'i. He's a teacher of Hamad bin Abi Sulaiman, and Hamad is a teacher of Imam Abu Hanifa. So Abu Hanifa, obviously, he's influenced by his teachers, they are influenced by their teachers, and eventually the fiqh they are all learning, it's coming from these 2 great Sahaba. So first of all, we know that the fiqh of Kufa is influenced a lot by these 2 Sahaba, and obviously there were other Sahaba as well. Secondly, it's very important to understand what the context of Kufa was at that time in the 1st century. Kufa was conquered from the Persians. So in those early days, there were Muslims living in Kufa. Most of them were the soldiers and the families. There were Persians, Zoroastrians, Jews, pagans, and other different religious groups. So in Kufa, there are lots of different races, there are lots of different religious groups. The environment of Kufa is very different from the environment of Medina. In Medina, everyone's a Muslim. So the fiqh of Imam Malik is mainly catering for all the Muslims. So it's going to be different from the fiqh of Kufa, because the fiqh of Kufa is different. It's catering for people from lots of different communities. Over time, when these people are converting to Islam, they're also bringing lots of new ideologies and concepts into Islam, and because of that, there's a rise in lots of different theological groups in Kufa. So Kufa is a place with lots of different theological groups from very early on. There were the Khawarij during the time of Ali. Later on, the Shia, as we know them now, this happened much more later on. There were the Mu'tazila, Murji'ah, and lots of other different theological groups. And obviously the fiqh of Kufa has to cater for all of these different theological groups. Apart from that, what's happening now to cater for these different theological groups, the fiqh of Kufa can be broadly divided into 2 categories. There were the Ashab al-Ra'i. They are the rationalists. They use a more rationalist approach to derive fiqh, because Kufa has lots of these new mas'alas, new issues rising, and they have to have answers to these. They have to derive law for these new issues. So they had a bit of a rationalist approach. And then there were those who were known as Ashab al-Hadith. These are the traditionalists. They were mainly the Muhaddith and those jurists who opposed rationalists and who opposed Qiyas. And also, in the 1st century, there is no such thing as loyalty to one school. There is no Hanafi madhab or a Maliki madhab. What happened in the 1st century, we had lots and lots of different study circles. There were many study circles, and students would learn from lots of different teachers. They would travel to different cities and learn from different teachers. And the concept of this loyalty to a particular school of law is something which actually took place later on, when the schools kind of shifted to more of a personalized school. So much later on, we find the Hanafi school now actually became a Hanafi school, where the founder is Imam Abu Hanifa, with a loyalty to him and to the school. This thing's happening much later on, and similar things that are happening to other schools of law as well. But in those early stages, there are hundreds of schools of law, and there is no concept of a loyalty to one school. People would travel to different schools, learn from different ulama, different fuqaha. And this is mainly our 1st century. So then moving on to the 2nd century. Now what's happening in the 2nd century in Kufa, the Abbasids had a revolution against the Umayyad in the year 132 AH, Islamic century we're talking about here, the Islamic after Hijrah 132. And what the Abbasids did, they shifted the capital, the Muslim capital, from Damascus to Kufa, because in Damascus, Abbasids didn't have any support. But what happens after they shifted, even in Kufa, there were lots of traditionalists and even the rationalists like Imam Abu Hanifa. They did not exactly support the Abbasids. Imam Abu Hanifa was politically very active, and he was very open about his political views, which did get him in trouble a few times. And initially he did support the Abbasids, but then he realized they were not sincere, and then he openly supported the Alids. Alids were the progeny of Ali radiallahu anhu. So in Kufa, generally there was this trend towards supporting the Alids. So what the Abbasids did, they decided to build a new city. They called it Baghdad, and they made Baghdad their capital. And Baghdad was a full-on city where everyone supported the Abbasids. And what the Abbasids did, they had a policy to kind of control any kind of rebelliousness coming from authoritative scholars. What they did, they would either threaten these scholars or they would start to enforce them to work for them. So Sufyan al-Thawri was enforced to work for them, but he ran away. Imam Abu Hanifa, it is said that he was also forced to work for the Abbasids as a judge, and he refused. But what we know for sure is that Imam Abu Hanifa was imprisoned by the Abbasids. He was tortured in his old age, and he actually died because of that torture. So, you know, when a scholar, they actually really stick up for the haqq and they are tortured for that and they pass away, even after their death, their authority actually increases even more compared to when they were alive. So they become a very strong authoritative figure. And, you know, a lot of our previous scholars, they were actually tortured. You know, Imam Abu Hanifa, Imam Shafi'i also, Imam Ahmed bin Hanbal. And then moving on to after Imam Abu Hanifa, he had a very famous student called Abu Yusuf. Abu Yusuf, he learnt his fiqh from Abu Hanifa and many other scholars, as was the trend of that time. He was the mujtahid, and he actually had his own independent study circles as well, because this was the norm at that time. So Abu Yusuf, he actually decided to work for the Abbasids, in contrary to his teacher, Abu Hanifa. He never wanted to work for them, because Abu Yusuf was more of a apolitical person. He did not want to get involved in politics. He just wanted to do his job as a qadi. He was Qadi al-Qudat, the Chief Justice. So he's like, I'm just going to do my job, and it's nothing wrong working for the Abbasids. Because what happened after Abu Yusuf actually starts working, a lot of the fuqaha, they realize there's actually benefit in this for them. So the Hanafis, they kind of start this trend of being apolitical. They don't want to get involved into the Abbasid politics. The Abbasids really like that because there's no rebelliousness coming from them. So the Abbasids actually support them, and they start to appoint more and more Hanafi jurists. And this is the 2nd century, okay? So towards the end of the 2nd century, more and more Hanafi jurists are being appointed in Kufa, Baghdad, and Basra. So Iraq, towards the end of the 2nd century, it's really being influenced and dominated by the Hanafi school of law. But when I say the Hanafi school of law, it's not the kind of school of law we think right now. These judges, they would learn from lots of different scholars, but they had some sort of loyalty towards the Hanafis, you know, it may be in terms of the methodology they would take on from the Hanafis, but they were somewhat Hanafis, these scholars. And this is the beginning of this trend of having a loyalty towards a school, and these schools becoming personalized and over time being attributed to a founder. So Abu Hanifa never started school as a personalized school of law where he demanded loyalty from his students. Neither did Imam Malik or any other imam. But this is a process that took place over time, and the schools kind of evolved from those study circles over time into personal schools of law where students have loyalty to that school of law. Furthermore, Hanafis were inclusive of different theological groups. And this actually benefited them in the 2nd century. So Hanafis had a lot of Mu'tazila, and Mu'tazilas, they gained the support of many Abbasid caliphs like Ma'mun, Mu'tasim, and Wathiq, and this did help the Hanafis in the early days. Also, many Hanafis were inclusive of the Murji'a beliefs, and that kind of helped them in spreading in the eastern Iran. But moving on to the 3rd century. In the 3rd century, these different theological groups were under scrutiny. So what happened? There was something called the Mihna, Inquisition. So the Abbasid caliphs, they began to force the Muslims, mainly the ulama, to take an oath and say that the Quran is created. So this was happening for the first time, that a caliphate was enforcing a particular theological belief upon the Muslim community, upon all the Muslims. So a lot of ulama, they kind of, if they didn't take an oath, they would be imprisoned, so they kind of felt compelled. But one famous figure, as we all know him, Imam Ahmad bin Hanbal, he stood up for the truth, and he refused to take an oath, and he was imprisoned, and he died. And after his death, the public generally went just against the created Quran, and the traditionalists, the Ashab al-Hadith, had an upper hand. By the end of this 3rd century, that's when the Sihah Sitta, the famous 6 Hadith books, were also written. So now the Muhaddith, the Jews who were pro, Ashab al-Hadith, they all had an upper hand. So Mihna was this catalyst that actually subdued the rationalist support from the caliphate. Also, what's happening in the 3rd century is that other rival madhahib, the schools of law, are also gaining a lot of prominence. And obviously this becomes a kind of a bit of a challenge and a threat for the Hanafis. So Malikis are being appointed as qadis in those cities where once, it was always the Hanafis, like Iraq, Basra, and Baghdad. Shafis are also emerging in these cities, and after the Mihna, the Hanbalis are slowly kind of gaining prominence as well. So now these schools of law, which are gaining prominence, they are all challenging one another. So there's a lot of challenge. And what they all are demanding from one another is an agreed upon methodology. So now what's happening, those study circles, those different study circles, they have to make some sort of doctrinal changes where there is an agreement by the other schools of law and from the masses. If these schools don't make doctrinal changes, their survival would have been difficult. So for example, at that time, there was a very, very strict traditionalist school called Al-Zahiriyya. Al-Zahiriyya were complete traditionalists, and they completely oppose any rationalist form of deriving law. For example, they completely oppose qiyas. Qiyas is like a form of comparison where you compare one rule to another, and if they're very similar, you kind of give the same hukm. So for example, in the Quran, this is the most famous example actually. Then in the Quran, we know that khamr is haram. So the reason wine is haram is because it intoxicates, and your mind stops working. The Quran doesn't say that the drugs are haram. There are no hadith saying that either. So what the ulama do, they compared the drugs to khamr because they both have the same effect. When someone takes drugs, their brain also stops working, just like khamr. So therefore, the drugs come under the same hukm as the wine. That's what qiyas is. So what happened now? The Zahiriyya, they were completely not for qiyas, not for any kind of rationalist approach in deriving the law. So what happened? The public at that time was not willing to support extreme traditionalists or extreme rationalists. All sides had to come to some sort of a middle, agreed upon method. And those who refused to, make any adjustments actually became extinct, and those schools didn't exist. But all the 4 schools of law that we know now, all of these 4 schools made doctrinal adjustments because survival was important. They had to come up with something in the middle. So what happened? Eventually, all the four schools of law agreed on the hierarchy of the sources of law. So in this hierarchy, right at the top, it's Quran, and it's always been Quran. The second source of law after the Quran was now Hadith. And Hadith became the second source of law because of this pressure from the traditionalists. The third was Ijma', and the fourth was Qiyas. Now, it's very important to understand Hadith because there is this misconception that the Hanafis didn't utilize Hadith. This is a great misconception. It's not true. Hanafis and all other schools, they all utilize Hadith as a source of law from the beginning. But what happened in those early study circles, they followed something called Sunnah. Sunnah was more broad than Hadith. Sunnah included the Hadith, Sunnah included Seerah, Sunnah included Aqwal al-Sahaba, the statements of the Sahaba. Sunnah included Aqwal al-Tabi'een. So Sunnah, generally speaking, is very broad. Also at that time, the three main centers of these Islamic schools of law were Hijaz, Iraq, and Syria. And all three of these centers had some sort of variations when it came to Sunnah. So Sunnah, in certain times, it could be a bit more localized because you're in Sunnah, you're also including the Aqwal of Tabi'een and Aqwal of Sahaba. And those Sahaba and Tabi'een lived in those cities. So Sunnah kind of had those local variations. For example, the Maliki school of law, they follow the continuous practice of the people of Medina. This was a Sunnah for them. So what these traditionalists are fighting for, they're saying no more local variations of Sunnah. We need to have a universal law where Hadith is right at the top, and it's not like other sources of law are being rejected, but they don't have the same level as Hadith. So Hadith is at the top, then somewhere at the bottom in those sources of law there can be Seerah, somewhere at the bottom can be the Aqwal of Sahaba and the Aqwal of Tabi'een. But all of these sources of law, all these other sources of law are somewhere at the bottom, not at the same level of Hadith. And this is what all the four schools of law agreed upon, that the second source of law is going to be the Hadith. So all the four schools of law also agreed on Qiyas. But now Qiyas had more systemized method. So the fuqaha, when they're generating these laws, there are limitations and methodology set for them. So you don't exceed limits just using your ra'i, and there's a particular method where everyone's kind of following that method. Now these doctrinal changes over time, this is happening a lot in the 3rd century. So 3rd century, there's these great doctrinal changes that are taking place. And this leads us to our 4th century. And in 4th century, what happens? There is this new genre of writing books on usul al-fiqh, on the Islamic legal theory. Islamic legal theory existed before as well. One of the earliest to write about Islamic legal theory was Imam Shafi'i, and it was being written down, but it was the 4th century when this became like a literal genre where all the schools of law, all the great jurists, these jurists are great lawyers. They are investing a lot of time in writing books on usul al-fiqh. So it's in the 4th century that every school of law has this comprehensive fiqh and comprehensive usul al-fiqh. Usul al-fiqh are the principles on which fiqh is based. But these principles were written as in the forms of books much later on. And only when these principles, the legal theory, was all written down in the 4th century, the early 4th century, that's when these schools of law were established. They were formed as a doctrinal schools of law the way we have them now. Also, what's happening over these 4 centuries is that there are many jurists. These jurists are developing and modifying and adjusting the law. So to say the Hanafi school of law, the founder is Imam Abu Hanifa, it's not exactly correct. He was an authoritative figure, and a lot of his students, when they are inputting their efforts, their work, they're attributing it to their founder. Because by attributing it to the founder, the aim of all of these great lawyers who come much later on is that they have a loyalty towards a school. So the effort is to establish a school. When the effort is to establish a madhab, a school of law, everyone's attributing the work they're putting in to the founder. But the reality is, the school of law, the Hanafi school of law, and all of the schools of law that we have now are the outcome of thousands and thousands of qualified jurists over 4 centuries. Now, all of these thousands and thousands of jurists, they were not just doing blind following. These were great lawyers who studied for years and years and years. They had great experiences. It's like they had lots of PhDs. This is how qualified these scholars were. And also these scholars, they cannot all err. They cannot all just be making a mistake. So to say like, I can just take a Bukhari, Sahih al-Bukhari, and read a hadith for myself, and I would just know, I'm doing the right thing, I'm following a sunnah. Yes, you might be following a sunnah, but isn't this what the scholars were doing from the very beginning? They were all following sunnah. But the aim was to make the law, the Islamic law, it should be universal by following hadith. So obviously there are going to be differences, but the differences we have now, they're all secondary differences. They're not primary differences. All the schools of law, they all actually agree on all the primary concepts. It's all the secondary things, there are disagreements. So you'll hear some sort of accusations. Oh, Imam Abu Hanifa didn't use hadith. No, it's incorrect. He did, but at that time, it's more of a sunnah approach. Yes, he's using hadith, but over time, the Hanafi school of law, just like all other schools of law, it took 4 centuries to develop. It was an organic process, and this process of the 4 centuries, with the efforts of thousands of jurists, is what was accepted by the multitudes of people, and not just the people. The 4 schools of law accepted one another. They came to an agreement with one another, and that's why they survived. Whereas many other schools of law who did not want to make these agreements with one another, they could not survive. There are other reasons as well why the schools of law did not survive, but the survival of all of these schools of law depended on their unity as well. And the unity came by agreeing on primary sources of law. Also, you'll find some people saying, why can I not, mix different madhahib? Honestly speaking, there's nothing wrong in mixing different madhahib up. You can follow something from Hanafi school of law. You can follow a different law from the Shafi'i. There's really nothing wrong in that at all. It's just generally easier when you're following only one school of law. I've been teaching and learning about Islam for the past 11 years, and honestly, it's just so much easier just to follow one madhab. But I won't say I'll always restrict myself to Hanafi madhab. If there is an easier opinion from the Shafi'i or the Malikis or anyone else, and I find it easy for me in that time, I would follow it. But it's just always easier. Seriously, it just makes life easy when you're following one madhab. And if you think you're just going to read one hadith and you know the law, trust me, that's not how it works. It's just like, can I just read one book on medicine and become a doctor now? No, I can't. You can't just read one hadith and think you know the law. It takes lots of professionals to actually derive law from the sources. It's a very difficult task. It's very challenging. It takes a lot of research. And it doesn't mean we shouldn't study and we shouldn't try. We should. I'm not saying we should just do blind following. We should always use our own brain as well. And if you agree with a different opinion from a different madhab, go for it. This is nothing wrong. You don't have to have that strict loyalty like I'm Hanafi. I'm kind of like those early study circles when they went and learnt from all different ulama. But because it's easier just following one school of law, it just makes life so much easier just being a Hanafi for myself. It's really up to you what's easy for you. A lot of time people think if they're going to follow the more strict fatwa, it's just going to make their taqwa very strong as well. It's nothing like that. Islam is a very easy religion, and follow what's easy for you. And I hope this was beneficial. Take care. Assalamu alaikum.